tight, can you see it? Streaming the truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness turns tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Good score. I believe that search warrant is 21SW0376. Yeah. So, what I'd like to say about that particular search warrant and also the application and the affidavit of it is that this was a third party, big score. And basically, the state went and got a search warrant for the information from that store about Mr. Long. And it is our position that this was in violation of the Fourth Amendment and in violation of the Georgia Constitution, in violation of the Fifth Amendment due process, Fourth Amendment, Fifth Amendment of the United States Constitution, and also in violation of Georgia law. The Georgia Firearms Industry Non-Discrimination Act of 2024 protects the privacy of financial records associated with the purchase of firearms. Section 2K, 2B prevents gun registries from sharing the records of the individuals who buy the firearms. This basically means that gun stores, they have their records of inventory, and given the protection of the privacy of firearm owners, the seizure of confidential information related to owners of firearms violates Section 2K, 2B. Basically says that in terms of condition of disclosure, no agency shall disclose any record which is contained in the system of records by any communication to any person or to another agency, except pursuant to the individual whose records they have requested. So we believe that, one, we do have standing to challenge that particular search warrant to this third party store. We also assert that it was a violation of Mr. Long's Fourth and Fifth Amendment rights under the United States Constitution, and we also assert that this is a violation of Georgia law under the Georgia Firearms Industry Non-Discrimination Act. don't know if the state wants to respond.
No, the third-party doctrine is well established. If there is an issue with the violation of the statute, then it would have to go by the definition of the statute. Maybe Robert Aaron Long has a reason to sue him, but that's not something that reads in constitutional law. So essentially, if I give the calls that I make to a phone company, that phone company can give law enforcement the phone numbers that I call. If I do business with the bank, the government can get the information from the bank without violating my constitutional rights. This is not something that is protected under the Constitution of either the state or of the United States, and so this is something for which the exclusionary rule does not apply.
Sort of law enforcement exception.
So I have not looked at the legislation that you referred to, the Non-Disclosure Act of 2024, Section 2K2B. I can check into that for Your Honor. However, this is a constitutional claim.
What's the section?
Non-discrimination act.
Is it official code of Georgia?
I'm sorry.
Is it official code of Georgia?
I'm not sure. But I'll give you, yeah. Georgia Firearms Industry Non-Discrimination Act of 2024.
Is it covered under the official code of Georgia? OCGA?
It's not OCT.
One more time, what's the name of the act called? Mr.
Yes.
Lamar, what's the name of that?
Georgia Firearms Industry Non-Discrimination Act of 2020.
Mr. Lamar, you decided 2K2B. You only want the first number for what the code section would be for that?
Yeah, sure.
You all try OCGA 10-1, dash 40. Lamar, anything else in regards to
Yeah, I
that?
think- Yes, Your Honor. I was just also, I was just add that even though that code section, as we look at, seems to focus more on financial institutions, I believe that the, joint power of that, seeks to create greater privacy for firearms holders. I mean, I think practically, anybody in here has gone to a reputable store, or gun store to buy a firearm, and I've done that. There was no expectation, that the information that I shared in terms, which I knew was gonna be run through the, registry background check, would be open to anyone just to come in and see it. So I felt like I had, expectation of privacy, and I believe that every citizen does. So that's the only thing I would add to that.
Your Honor, thank you for finding code section because it wasn't mentioned in the motion. And it was not something that I could find based on what they were saying orally. But it appears that this is not germane to individuals and their transactions with gun stores. That would be a much larger broadening of this. And so there is an exception for law enforcement mentioned, but again, this is all for financial institutions, so it doesn't really speak to the circumstances they're talking here because no part of it seems to be. But in any case, unless there's a statute specifically saying under Georgia law this gets excluded, this doesn't benefit Mr. Long because his is a constitutional claim, not a statutory claim. The exclusionary rule is a constitutional product of both the federal and state constitutions, and they have not shown any kind of constitutional violation because they've not shown that the third-party doctrine that ordinarily applies when you give information to another entity wouldn't apply here.
Mr. Lamar, had the police came, seized or taken this third party, but they didn't apply for a search warrant, and it was nappy, and then they wanted to know about the specific purchase as well as some other things later that the client allegedly going to this particular store and video in that regard. So they went through the proper procedures and based upon an affidavit and probable cause that was determined and went ahead and sought it for this particular store to give them these particular records and video. So I don't see anything that would indicate to me that they didn't have the right to go and look at it, get the records. There's not a statutory exclusion, and they did seek the records in the manner prescribed by law. I would agree with you had they just snatched them up or came in and said, let us look at this stuff without a warrant, they'd have some problems. But they didn't do that in this case, so I'm denying this particular motion. So, Mr. Armstrong, if you'll submit a suit order.
Yes, Your Honor.
Let counsels, Mr. Bell and Mr. Lamar, take a look at it for form, okay?
Yes, sir. So, Your Honor, where I'd like to go now is, and I would actually ask for the assistance of the state. I just want to make sure we're all on the same sheet of music. There is a search warrant that the state,
Which one?
and that's the one I want to make sure if it's number states,
Tell me the warrant number if you want.
right, yeah, whatever. Zero, I believe it's 0622. It's the one for that in terms of Osco Park. So there's a series of Osco Park states. One, states five, the duplicate.
Says, give me the last, the warrant number, the last four.
0368 0390.
036. number is that one? Stage what?
State's number one, Your Honor.
Stage one. All right, I have that one. What's the other one?
0390.
That would be stage 5.
Yes, sir.
I have it. Stage five. Oh, yeah, I have one in five.
Yes, sir.
Okay, I have it. All right.
So in that search warrant,
Which one now? Which one? Referring to which one?
states stage 1 and stage 5, which is the blue.
Okay, all right.
Mr. Long's, Mr. Robert Long, his father, this is one, I believe, where the cell phone was accessed, in terms of an app, that basically was able to track, Mr. Long. And our argument as to why this should be excluded, Your Honor, is that under Jones v. State, 321, Georgia 137, that's a 2025 case. Also under Carpenter, which is a Supreme Court case, we're arguing that individuals have an interest, and also, I'm sorry, Williams v. State, also again, have an interest in a defendant's own location, history, and that. So I want to try to give the context of this, you know. It's one thing for you to have a tracking app, and you put it on Instagram, or you put it on another type of platform that is open to the public, open to a number of people. But this particular app, the Find My Kids app, was only shared between Mr. Long and his parents. Now, the phone that it was on was his father's phone. And so, and the law and where we've been going with this is still not as sure on this, because these are kind of novel issues that continue to come up. And they were able to, the state was able to, you know, the police were able to track Mr. Long on that. And I believe the state is arguing that, one, that we have no standing to challenge this particular seizure, and it is a seizure, in terms of tracking Mr. Long. Our argument is that there may not be an absolute expectation of privacy, but there is a limited expectation of privacy that we believe Mr. Long had under the Fourth Amendment. And we believe that it was violated by the state using that Find My Kid app through Mr. Long's father to track him. And we believe that it should not be used, it should be suppressed, and should not be put forward. I cited the case law simply and basically cited the quotation in terms of out of Jones. It said, in most, defendant had a Fourth Amendment interest in defendant's own location history data. We are asserting that once the state, or should I say the police, knew there was an app, that they should have gotten a warrant specifically for that app. They did not do that. And so we're arguing that the information, the tracking, all of that should be suppressed, and the state should not be able to use that.
Okay. Gentlemen?
Yes, Your Honor. Again, this goes back to the third-party doctrine, and citing from Carpenter, the decision that we're all very familiar with that Mr. Lamar mentioned, typically, under the third-party doctrine, a person has no legitimate expectation of privacy and information he voluntarily turns over to third parties. Now, Carpenter dealt with cell site location information, the information that you cannot have a cell phone without providing the cell phone provider that shows your location. And they said that in those unique circumstances, at least when the state is seeking, I believe, 7 days or more of cell site location information, they have to get a search warrant because it is so expansive as far as what it shows about a person and their habits, but also because you can't have a cell phone without, you can't use a cell phone without giving away this information. So it's something that is ubiquitous and you can't deal with. In this situation, we're not dealing with cell site location information in the sense that what you provide a cell phone provider. This is something that he turned over to a third party, his father. This is a 21-year-old man. This is not a situation where it's a 6-year-old or something strange like that might have an exception about it. This is a case where one adult shared his location with another adult. My best friend, as unbeknownst to me until recently, shared his location using a Facebook or some app that's on iPhones. I can tell you at any point in time where he is physically located. That is information that he has voluntarily given over to me. It's not a choice. That was a choice, unlike cell site location information, which is not a choice. And so absolutely, assertion based on the idea that because it shows location information that this is different, it's not. It would be the same as if I called up my friend and he told me where he was. That's information he voluntarily shared with me. I can tell the police he said he was at this location or something else like that. It is the exact same thing. It is nothing else than an individual sharing information with somebody else. Basically, they have no expectation of privacy in information they have voluntarily disclosed to someone else. And under the third-party doctrine, when you have shared that information with the third party, the government is typically free to obtain such information from the recipient without triggering Fourth Amendment protections. Carpenter is a very limited exception to that based on, again, that you don't get to choose if you... than your use of the cell phone. So, by the way, we still don't understand how they would have standing to assert a Fourth Amendment interest in his father's phone, but we submit to the court that they fail on both counts in the sense of this is not something that he would have standing for, but also he shared this information with his father, so it's something that his father was perfectly well able to give to the state.
So this was his dad's phone?
Correct. This is, so essentially what happened is they found out, that they looked at the news, they saw, that's our son. And so they contacted the police and said, we have an app that tells us his location, here's his location. That's what happened, essentially. This is not, they didn't go into Robert Aaron Long's phone to find his location. They couldn't do that because they'd have to find his location, they'd have to find him first. So this is somebody else's phone entirely.
Your Honor, there are absolutely some things that I think that Mr. Armstrong said that I think we all say are reasonable and make sense. I think that this is a area that has more exploration go into, and I think the case law says that. This is where we're kind of straddling both sides in terms of GPS, tracking. What actually do you give away when you have a cell phone? I think it's different when you buy your cell phone and you realize that there are certain apps, certain things that are just germane to it. I think that's different from when you say, Mr. Lamar, I'm gonna, and I think Mr. Armstrong talked about it. Mr. Armstrong, this is what you and I are going to do, all right? And I have no expectation that you're gonna share it with Ms. Judge Glanville or Ms. Bell. I have no expectation. This is just between me and you, Mr. Armstrong. So therefore, when you pull it up on your phone, it is a shared app, not an open app. So that's where I would differ in terms of saying, well, once you give it to a third party, it's open season. We disagree with that. A shared, I'll give you an example. We just got to talk about financial institutions, right? It's been my experience, negatively in one sense, is that I learned not to do joint accounts, right? Because I can't do anything in terms of a bank, sometimes with that, when you have a joint account, bank says you have to have the consent of the other party. I would argue that this is similar. Access to Mr. Long Sr.'s phone is one thing. Access to a shared app is another, because the understanding between the two people is that it's just between us, not between us and the world.
No, not necessarily. That's the problem. That's the challenge with the third party doctrine is that, you know, if you share information with a third party, you understand that that third party might share with somebody else and you don't want them to share with. I mean, that's just the reality of the circumstance. I mean, that's just, and it's not like, in this particular circumstance, the police took Mr. Long's phone. Clearly, they would need to get a search warrant for it. You know, clearly they would need a search warrant for other types of cell information. But for a location tracking device, it's on his father's phone. Do you have any other argument you want to make?
I think that the court should feel free not to necessarily just say, okay, this is straight third party doctrine. We don't believe that it is. And we're asking the court to look a little more so away from it, because I think the case law says there is not an absolute, but a limited interest. And we are asserting that that limited interest, given this particular situation, not just your friend, but your father. And I understand third party doctrine now, I do. But we're in a different kind of place here. So that's the only other argument I have.
There's one thing I wanted to answer, just because it was what Mr. Lamar focused on in the last argument he provided, that there was an assumption that it would only be used for certain purposes. I've quoted two sentences from Carpenter. The sentence in between the sentences that I've quoted is actually relevant to that determination, and that is in talking about the third party doctrine being about taking over information from somebody else. That remains true even if the information is revealed on the assumption that it will be used only for a limited purpose. And it was citing a prior Supreme Court decision, United States versus Miller, 425 U.S. 435. So even if he thought that his father would only use it for certain purposes, that limitation on what he believed it was going to be used for does not apply, because the main thing is that he turned it over to that other person.
Nothing is from the defense.
According to looking at states 1 and states 5, two things. If you take a look at states 1 and states 5, the court is of the opinion that definitely the third party doctrine would apply in this particular circumstance. And even though it's his father, it's not inconceivable that his father wouldn't share this with third parties. So given that, and given what's been proffered and what's in Washington in states 1 and states 5, this court is of the opinion that he doesn't have any standing in this particular circumstance. And so I'm going to deny the motion to suppress those two particular
there was two things that we were going to say about them.
No, about the third party doctrine, and then I said about standing.
Okay, thank you, Judge.
Yeah, I'd like to, just have 5 minute cover break.
Oh, absolutely. Okay. All right, ladies and gentlemen, we're gonna take 5 minutes, take comfort, and then we'll come back out, okay?
Thank you.
We're in recess.
Is it 5 minutes, Judge?
Yeah, 1 minute.
Okay. Mr. Long? Mr. Long, you use the restroom? Okay. Oh, come on. I'll let you back. Come on, I got you. Come on. You got it.
How are you? Yeah. Over there.
Just got one more? Just one? You guys almost finished, right? Yes, sir. Almost, okay. Yes, sir.
So I have that took care of 1, 4, and 5. Okay. Right. Well, that's.
We should be long. Oh, for the 20 minutes, 15. Sergeant Moore. Sergeant Moore.
But, the guy that came home for Christmas, and they were eating on the street. So it's like, I just assumed it was like, here's the vote, here's the thing.
It's basically,
Okay.
it's basically that stuff.
I didn't want to walk over towards you, because I don't want to get, I don't want you guys to feel like, come around. You can use me those rules, things are gonna switch, if I'm not voting, I don't know where.
I know, well, they're hard to find because they're old, and so it's just finding it's going to, a federal depository.
Oh.
In terms of, well, no, it's Georgia State, and so if you're the state school,
The federal depository?
so it's state and federal. So if you're state, if you're a university, state, and so, you're required to have a public library. There's a public library, so they have it online, and I know that was so anyway, moving on.
Send me like the rules and things, you can just say PDF to me, because,
Yeah, so,
I've been over to the website one time, and
yeah, so they only post the current ones. Everything else is.
From past year.
Yeah, everything else, they only place the current ones for this year on the legislative website, everything else is already in the
often they change the rules all the time.
No, they don't, they actually are pretty standard, but they just put a 2025 year on it. This is what you might see. So they put a new color on it, that's basically the same stuff. The other thing I have is the bill. What, so you saw.
I've seen the cops of the bill, which identified as, that is something we can link to off of.
Right, so that's the only thing, those are the only other things I have. I did just to, because I'm gonna talk about it, but I'm not putting this in, just to, the numbers.
Oh, the numbers I think are
The numbers are
necessary,
in there.
and they're in your filing, so like.
Right, but I'm just gonna talk about it, I'm not putting this in, I'm just gonna talk about it. Because one of the things that you have to establish with the code is, that there weren't a significant number of absences such that the numbers would affect. Yeah.
You mean the moral?
The two votes do.
Well, I mean, like, there's 180, so you have to get 91 passed, and so, like, there's well more than 90 people present. I don't know if the forum would be.
No, it's, in terms of the vote, when you're establishing the vote, it matters how many people have been absent or not voting in terms of the determining number factor. But for 2/3, in order to pass, then, they would need it more in regards to the vote we're talking about, absence that we're talking about.
Yeah. Well, you do, like, numbers either way are not gonna make 2/3 of anything.
But I just wanted to make sure I had everything.
No, you have to, yeah. You can also witnesses, that's what it's like, I have no idea who testified.
Remain seated, court come to order.
Thank you. Yes, Your Honor, back on the record. Now, I believe this would be state's exhibit. This is warrant number, search warrant number 0375. I believe it would be state's exhibit 3. Okay. And this is the 2008 Hyundai Tucson. I believe Investigator John Swindler swore out the warrant and submitted the affidavit for the search warrant to the magistrate. I would direct the court's attention to the last paragraph of Investigator Swindler's affidavit, where it says, due to the vehicle being used in commission of the crime and the time of the arrest, statements made by the suspect. The acts of violence committed on 3/16/2021, and with the statement, your client is requesting to search the vehicle that Robert Aaron Long operated, possessed, and used prior required in doing this crime and to locate the fruits of the crime of murder and aggravated assault. As the court knows, under OCGA 17-521A, that we have to have probable cause, we have to have facts that are sufficient to show probable cause that a crime has been committed. And probable cause is only present when facts presented in the affidavit are truthful and reliable. And that's under state policy 132, Georgia Act 17. That's a 1974 case. We submit that in this particular affidavit, that the facts are not totally truthful nor reliable. What I'm arguing in terms of that last paragraph is that investigators want to refer to the statements made by the suspect, the alleged statements, and I kept going through this to say, well, what are those statements? And the alleged statements should have at least been presented to the magistrate in order to give the magistrate a better idea of probable cause. I think what the affiant does is just gives some facts that say, okay, he was driving this car. And a lot of us, we might say, well, that's enough. But when they talk about the statements that were made by the alleged suspect, is really nothing here in terms of.
Okay, but here, I just want to kind of
Okay.
interject.
Sure.
Didn't the affiant swear also, the judge also received oral testimony. So with oral testimony, it's on page 5 of the
Yes.
warrant. Doesn't, and he's also sworn, doesn't that indicate that the judge was told by the affiant all of the facts to establish probable cause? I mean, with oral testimony, that usually that's a specific issue that is checked off on the warrant, and he's also sworn. So isn't there some?
You said there's an additional reliability
Well,
with that.
that the affiant told the judge under oath all the facts necessary for the judge to make a probable cause determination. I mean, I'm just asking that. And also, wasn't there also something that the affiant also in the very last, almost on page 4, he indicates that there's a vehicle, this 2008 black Hyundai. Wasn't that also something that may or may not have been used in this purported crime?
No,
So you got like, it says, due to the vehicle being used in the commission of the crime and the time of the arrest, statements made by the subject. I don't know what the statements are because we don't know. They're not in the text of the warrant. Yeah, it would have been great to have them, but isn't there some reliability that the judge found probable cause based upon all of what the affiant told him? It wasn't like, for example, if you had, that was the only thing that was said, and it was in the warrant, maybe a little more of a stretch, but you got a fairly substantial 5-page statement made by the affiant, sworn to by the affiant. Also, no, actually, it's about 2.5 pages. I'm looking at the actual search warrant itself, and that's page 1 and 2. That's the warrant itself, and the affidavit is pages 3 through 5. But it does lay out in pretty good detail, along with oral testimony that the magistrate would have considered. So, well, could you address that for me?
Yes, Jim. I think that there's the tendency that you could say, well, it's pretty clear that given the fact that they did check the oral testimony, as the court pointed out, given under oath. But, this is the age-old argument we made about grand jury transcripts, that I can't stand here and say on behalf of Mr. Long that that's probably what happened. I would like to know that that did happen. Now, I think the court is right when the affiant, investigator swimmer, refers to those statements, right? But it's left up to the court, of course, and then it's left up to me as a defense lawyer to stand up and say, well, you know, Judge, I'm fine with that, but we're not fine with that. Because he talks about the statements as the reason for having this search warrant granted. And because there's no real meat about the statements in the affidavit, even one, he talks about statements made by the suspect, and he also talks about witness statements. So that leaves a lot for me as Mr. Long's defense lawyer to say, well, maybe he said this, maybe he said that. The better idea for me is at this point to present to the court, this is the reason for this search warrant to be suppressed and those items not used because we'll have to speculate as to what was said to the next. That's all I have.
Okay, Mr. Armstrong?
Yes, Your Honor. This is a claim that, not that the four corners of the affidavit are insufficient, but that there's a problem with an assertion within it. It seems that this is a Franks versus Delaware claim, which is basically saying that something is false in the affidavit. But that's something for which the defendant has to make a substantial preliminary showing that a false statement was knowingly and intentionally made by the officer or recklessly made in disregard for the truth. Nothing can be farther from the truth in this situation because I can represent to the court that Robert Aaron Long made a statement. It was inculpatory. And so this is not a false statement that he made a statement. There's nothing wrong with this, and even if they were able to show a Franks versus Delaware claim, which they haven't because they haven't presented any evidence to show that there was something off or wrong about what was stated, you would remove the offending language, which means that from this affidavit, the court removes solely that part of the last paragraph that refers to his statement as opposed to all the other information. This affidavit very clearly establishes that the probable cause for the need to search his car, because as Your Honor mentioned, he was observed leaving the crime in the car. And so this is something for which probable cause in the affidavit is absolutely present. And the reference to his statement in the last paragraph in no way subverts that. I would also point out that when you get a search warrant, it flips the presumption, and the presumption is that the search was valid. And so in addition to everything else, I just mentioned that general rule. But this is a claim that should be denied.
If I could add, in opposition to what Mr. Armstrong, I don't believe I'm making a Frank's argument. The argument I'm making is that if the state says that even if you take out his reference to the statements, that this stands alone as enough probable cause, I don't agree with that, but I can see that argument being made. I don't think that's what Mr. Armstrong is doing. What he's saying is that there's an indicia of reliability because I can tell you he made a statement. Well, we know that, yeah, and so did Investigator Swiller. He's saying he made a statement too. But also, what statement did he make? What did he say that gives you an indicia of reliability, of truthfulness, that then says that you have a probable cause?
Any answer?
I'm done.
I'm going to deny the motion in regards to the strip ratio. I think the opposition correctly was 17-5-1.
Moving on, Your Honor, I believe this is going to go to State's Exhibit 7. That's a buccal swab, and it's, I think the search warrant number is 0392.
Let's take 7.
Yes.
All right.
Kind of, I guess the court says, Mr. Moore, you love to stay on these last paragraphs.
Sure. I understand that, John.
Looking at the last paragraph.
So,
Thank you.
okay. So which,
The last paragraph, of the affidavit.
that would be on page 3,
Yes, sir.
and that is,
Where it starts, the suspect possibly could have left a DNA profile on this weapon, linking evidentiary value to
I answer.
okay, to the use of the weapon. So here, and I believe this is Investigator Swindler again. This last paragraph about the suspect could have possibly left, that it could have left a DNA profile on the weapon and clothing the bodies of the victims is not enough for probable cause. We argue that the weapons and bodies should have been tested, or at least there should have been some indicia in terms of just possibility of DNA, and then the request for the buccal swab should have been made. We're arguing that basically put the cart before the horse in this particular issue. And there is no link to the weapon was established in this affidavit, that this weapon was used. In that paragraph, also it says the suspect was in possession and used a firearm during the acts of murder. There was no, at least in this affidavit, it's pretty clear based on the scene that firearm was used. I would even say that this says that the suspect was in possession of a firearm. But there was no link from that firearm to the bullets and the weapon, the ballistics that were used to identify how the victims were killed. And so there's a leap here that says, okay, just because we have this, we have a killing, we have a weapon, there could be DNA. I think that's in every situation, but looking at the four corners of this affidavit, again, we believe that this was a jump made that could have and would not have done anything. Ms. Malone was in custody at that time. There was not exigent circumstances that we need to do this right way, that the other link should have been made. Was there anything on the weapon that would point to we need to get a DNA buccal swab? Was there any evidence at the crime scene in terms of the bodies of the victims and the clothing of the victims that points to that?
So you have apparent, I'm looking at the affidavit on page 2, you've got apparent gunshot wounds, right?
Yes, sir.
So wouldn't that be enough for them to kind of further look at that particular issue? By finding the weapon, and or its use in potential testing for DNA or test DNA
Well,
or bodily fluids.
Yeah, I think what has happened is that, and please don't quote me, but in my experience, it's believed that a buccal swab or anything, blood being drawn from a client, anything, that is a very intrusive search. And I think when you have no evidence other than a weapon was used, many times, and I'll give you an example, we do, I believe, a lot of law enforcement do what they call GSR, gunshot residue. Gunshot residue test is a lot less intrusive than a buccal swab or than drawing blood or those.
Buccal swab, isn't it? It's swab your cheeks, right?
Well,
It's just
yeah.
cells. It's just my cells inside your mouth.
Well, Judge, I mean, somebody go inside my mouth, I consider that to be kind of
It's
intrusive.
in the tennis, right? So, okay, I mean, it's not as bad as doing that, but I do believe that in all seriousness, it's painless and it's not invasive. I know you're arguing that it is invasive, but is that your take for your client?
Yes, that it is invasive, yes. And so we're just arguing that they could have gotten more to tie Mr. Long to this in terms of probable cause than just jump into the conclusion that we need to get that. Yes, sir.
Yes, Your Honor. First of all, warrants would be read not in some hyper-technical sense, but as common sense. And this is something that indicates that this defendant has been arrested, that there is a firearm used in the shooting of multiple human beings, and And so we think that there's absolutely probable cause to sustain the affidavit as written. I would simply mention, as far as the issue of whether a vehicle swab is intrusive or invasive, I don't think that those words have necessarily been used in Georgia, but it seems that other jurisdictions have said that it is minimally intrusive, such as the Commonwealth versus Costa, Kostka, which is the Supreme Court of Massachusetts, 471 Mass 656. And as far as whether it's intrusive, Maryland versus King, a U.S. Supreme Court case, 569 U.S. 435, refers to a vehicle swab as an even more brief and still minimal intrusion. And so to the extent that the argument is based on the level of invasion or intrusion that's involved in a vehicle swab, it is by all accounts minimal. And so we said that the affidavit alone, when it's talking about gunshot victims as well as the defendant being arrested for those gun crimes, the testing for comparison against the firearm used in the crimes, I think that a neutral magistrate can reasonably make those conclusions. And so we submit the affidavit is sufficient.
That's all I have.
Taking a look at the state's 7 and an argument to counsel on the motion, I'm going to deny defense's request. At this time, the affidavit seems to be, and warrant seems to be in proper order. So, you deny that motion. I'm just doing the same thing, just being prepared for my signature. Okay, all right. What else you got there?
Moving on to State's Exhibit 8, Your Honor. That is search warrant last 40398.
Which one's that? States what?
Yes, sir.
Which states it is? Which states?
8. I'm sorry. Yes.
Thank you, sir.
State's 8. Yes.
All right.
Now, with State's 8, this is basically about an IG account, Facebook.
IGB, Instagram?
Yes, sir. I'm sorry, Instagram, yes, absolutely. Our argument here, Your Honor, is that this was unnecessary. There was nothing to support the assertion that the search warrant would jeopardize, in terms of the law, in terms of whether or not it would jeopardize the safety of the victims. There was nothing ballistics matching that particular firearm. And then the other argument, I think we've covered this before, and I think the court has ruled about the parents, having the right to turn over confidential information about Robert. We still maintain that third party could not give up this info. And looking at the last paragraph again, we believe that this is possibly a violation of HIPAA because of the therapy implications. This request impinges on Mr. Long's right to privacy and a privilege concerning his medical and physical health. Since the affiant had information about Mr. Long's mental health issues, the prudent thing would have been to delay this search warrant request and have a hearing on what privileges could possibly be violated by granting this request for a search warrant. I think when the investigators possibly discovered a social media account related to Mr. Long using the facial recognition technology under the username Artistic Spectrum, and then seeing that in the biography of the account holder identifies as a sex therapist, I think that at that point it's prudent to have held up. Because at this point, when you put therapy and access to someone online, it's kind of a red flag at that point that you should probably hold up. And they did not. And it's our argument that, again, that if you had just maybe just held up and looked at what other things could be done, because as we asserted, and as I asserted earlier, this could possibly, and we believe it's a HIPAA violation in terms of access to a patient's mental health and medical records without a clear hearing. And the one thing about, in terms of, I think the court could say, and the state could say, well, it's okay because there was a magistrate looking at the four corners of an affidavit. I think all of us in this room can agree that there's a reason that we have an adversarial process that our forefathers wanted that in terms of a defendant's rights versus the state's rights, and that there are times that there has to be both sides heard. In this particular situation, we believe it should have done that. Moving to the Find My Kids app, we talked about that.
Before we cover that, let me just ask you some questions about
Sure.
this. This Instagram account, and this is Artistic Spectrum,
That was the label, that was the name.
and this is the investigation found is on the 18th of March of 2021, correct?
Yes, sir.
So, is this, and you can, mapping, it says in this particular paragraph that the account holder identifies as a sex therapist. So is this potentially somebody that is, has a treatment relationship with this
Yes.
long, or, okay,
Yes,
all right. Did they actually, it looks like also from this paragraph, and I'm looking at page 6 of 6 on state, that there's a preservation request that went into Facebook. So did they submit this preservation request?
It is my belief that they did.
Were any documents found as a result of that?
I'm not sure.
State, were any documents found as a result of that?
No, the preservation request is to make sure that the account, if the holder was to delete it, it would allow the account holder to delete the information. That way, in between the time of the preservation request and then submitting a search warrant affidavit to the magistrate court judge, and the court was to sign off on it, then they were able to send it to Facebook in order to get the Instagram account and prevent the account holder from deleting the account off the information.
Okay, great. Have any documents been produced as a result of this preservation request as it relates to this particular username?
The Instagram account was for the account holder that we're talking about.
So documents were not tendered as a result of this?
They were tendered as a result of the search warrant.
Okay, all right. Have you seen those, Mr. Lamar?
Those documents?
Yes.
Yes, sir.
Okay, okay. Anything else in regards to this particular issue? I mean, in terms of the Instagram artistic account, artistic spectrum account?
No more, I remember that.
Okay, all right. In this particular circumstance, without having anything more, I mean, I'll grant the motion as to this. There may be another motion that may arise out of this, depending on what is said in those particular documents. But right now, without anything more,
Your Honor,
Yeah.
I believe the state disagrees, that just because he calls himself artistic.spectrum and had in biography sex therapist, It's his account, is our understanding. It's not a sex therapist's account.
We don't know that. I mean, I don't know that from this particular warrant. And that's what I'm saying. What I'm saying is there may be an additional issue that may present itself depending upon what was tendered. I don't know. That's not my role.
So they're seeking to suppress the material that was tendered based on the search warrant. And so what they're asking for is something that we never really get to another step if you suppress what was obtained by those documents. And I would mention that a reasonable magistrate can look at that information and realize that no actual sex therapist or therapist of any kind would have pictures of their clients on their Instagram. And so this is not ever going to be something from an actual therapist. And so I think the officers were one of the main things that they were looking for, right purpose to, were determine whether this was a social media account that was linked with Robert Aaron Long, who denied having any social media accounts.
Yeah, you know, my reply to that is, a lot of times the state wants to have it both ways. It's like, okay, it's the plain language of the paragraph, and from reading this paragraph, I come to the same conclusion that the court does, that there's something here that needs to be cleared up. If it's not a sex therapist, it's not a particular relationship, then let's clear that up. But I don't think the court, again, they're asking the court to make the assumption based on what Mr. Armstrong is saying right now, that this is invalid.
Who's the account belong?
The defendant.
So even though it says sex therapist, it belongs to the defendant?
Yeah.
Not a third party?
No, belongs to the defendant. And I think, and I may have been confusing, the preservation request is just to preserve the Instagram account. All the things, the postings, photos, and things of that nature related to the account, which the detective had been able to find based on his search of the internet, that this account had photographs of the defendant that were public, and he was able to view them. And because of that public viewing of the defendant's photographs, as it relates to the connection to this account, that's why he did the search warrant and affidavit. The preservation is just to make sure that no one can delete the account prior to the search warrant and the affidavit being received by here, Meta or Facebook.
Okay. All right. I understand. All right, Mr. Martin.
Not on that.
At this time. Okay, moving, okay, you want to move now?
Right,
to
just, to the,
location device?
Exactly. I think
Go ahead.
it's, I would imagine that the court's position is the same as it was earlier.
Make your argument, sir.
Yes, correct. And for the record, our argument is the same, that this was a violation under the Constitution of the United States and of Georgia, of Mr. Long's rights against legal search and seizure.
This is states 1 and 5, is that correct?
Yes.
Okay, all right. Anything else, Mr. Lamar, you stand?
No.
All right, Mr. Armstrong.
If this is simply the issue from before about the location information, then I made the argument.
Okay, Mr. Lamar, for the same reasons that the court articulated and warrants 1 and 5, deny that motion, okay?
Thank
Okay, what
thank
else?
you for letting me make that argument.
No, you're fine, that's correct. What else, anything else in regards to number 8?
Nothing.
Okay, fine.
Moving to State's Exhibit 9, I just need some help and
Which
clarity.
is warrant
I believe that is
0407?
Yes, Your Honor.
Okay, and that states 9?
Yes, Your Honor.
Okay, fine.
Yes, sir. Your Honor, I just want to check with the state. It's my understanding, and I just want the state to, if they could, state on the record what it is that they will use and will not use from this one.
So from this warrant, I don't intend to use anything related to this warrant because the items that were seized related to this warrant were items that were found inside journals. And inside those journals were what I would say are medical related documents for his sex addiction. So it seems like a direct assignment, things of that nature.
Just to clarify, it was a journal that had loose leaf papers in it, so the contents of the journal, Mr. Valley is not referring to, that's something the state doesn't intend to use, because it's in Mr. Long's own handwriting. It is the inserted material that they got an extra warrant for.
So based on those representations by the state, we believe the motion is,
Okay,
they're not gonna use.
okay, just prepare an order to that effect. States one, okay, what's the answer?
I believe, 2 and 6 are left.
Okay, here's one,
And-
one's ending in 039, 0391, and 0369. Correct? That's correct. So which one's which?
And I think 6 is the duplicate of 2.
So it's 0369, it states it's at a 3, and then 0691 states it's at a 6.
2. 3 was,
Excuse me, yeah, 2, that, no.
right, okay.
So 391 states 2?
391 states 6, and then 0369 states 2, Your Honor.
Sorry. Okay, all right. Okay, I have it.
Thank you.
Tell me which one you want to start off.
I think the main issue here, and I believe the state is arguing that, we don't have standing, given that this was the, residence of, Mr. Smith, it was someone else's residence, who owned it. But Mr. Long and another, Mr. Smithson were living there. It is our argument that we do have standing to challenge, this affidavit, in this search warrant, because this is where, Mr. Long had moved to. Our assertion is that at this time, when Mr. Long was arrested, he had standing to challenge the search at his mother and father's home, because even though he was staying there, it was not, and it did not seem, based upon the state's representation in terms of the testimony and the investigation, this was a permanent situation. And so therefore, the consent that was given, and the search that was given, we believe that we do have standing. So I think that's the first argument that has to be made.
Your Honor, just to make it easier, we're not contesting standing for the, I'm not ever gonna be able to say his name, the Smith case. Whether he was still with his parents, that home he moved out of, he was living with this man, even if just for a short period of time, so we don't contest standing for that.
Okay, what's that, which one is that one, sir?
2 and 6, they're the exact same warrant, they just were saved under different numbers.
Oh, okay, yeah, I was about to say, okay, so states 2 and 6 are the same, is that correct?
That's correct, Your Honor.
Okay, all right. So they're not gonna, states saying they're gonna.
All right. So the
They're gonna
concede that we have
concede
standing.
you have standing.
Yes. So, Your Honor, now we move to the affidavit itself. I think the gap here is that the affiant could and should have went further by confirming Mr. Long's attendance at the church. There's information that Mr. Smithson gives that the affiant includes in this affidavit that is at best having us to take a guess. I know that when an officer does an affidavit, that they're doing they should be doing their best to try to get as much information to the magistrate or the authority as possible. But here, it just seems that there's so many gaps within, and that you are left to make a leap, left to make an assertion about what it is. And the gap here is, that he attended this church and that he went to this church for this particular reason. And again, I know what we do in the law is we do Monday morning quarterbacking. That's actually what we do. And, and that's what we're supposed to do. Mr. Smith's was not a doctor nor a licensed therapist. And in order to really basically give a diagnosis to the investigative swimmer about, and I think there are several times he talks about religious ideology and suicidal ideations. But when I read it, when I look at it, I go like, well, where is this coming from? It's not necessarily clear how the witness that he talked to, that investigator Swinson talked to, came about in that. He said, well, he talked about, he said he's been prescribed antidepressant medication. We don't know what the medication is. How do we know, how does he know it's antidepressant medication? It could have been some other medications for other. So there's so many gaps, so many leaps that are made in this affidavit that we believe that is unreliable and possibly not totally truthful. Not that Mr. Medicine was trying to lie to investigator Swimmer, but there's a lot of assertions, there's a lot of jumping to conclusions that make this affidavit unreliable, Your Honor. And for those reasons, we believe that this report should be suppressed and the items that were seized should be suppressed also.
Your Honor, the state submits that this affidavit is perfectly fine on its face. It's very clear that I'm going to refer to him as James, as the affidavit does, because I would butcher his last name, and I try to avoid doing that. But this individual is recounting information from Mr. Long. This is information that Mr. Long orally conveyed to James. And so I don't understand why the officers need to do more. Probable cause is a low standard, and this is an investigation. We don't have to prove absolutely these things, again, especially since it is Mr. Long's own statements to James. And so that James is recounting to the officer. So I'm at a loss for understanding what is missing from this affidavit. The affidavit is full and complete and establishes probable cause for a neat reason to search the home that James lived in with Mr. Long, and we submit that this court should deny the motion.
No further.
Any further?
No.
Our court finds it based in terms of states, shooting the state citizen, in terms of the motion, as well as the arguments of counsel, the affidavit and more are proper under circumstances. So I'm going to deny the motion.
I believe we have addressed every one of the state's exhibits, Your Honor, I believe.
So Mr. Armstrong, on these particular motion and warrants, what do you think you can get us by?
By the end of the week, Your Honor.
Okay, that'd be fine. Just make sure you send copies of that, the proposal over to defense counsel. All right. Anything else we need to take up today? Because I understand tomorrow will take up motion number 55. You have witnesses that are going to be available. And then you also have the status and things done we need to kind of cover. All right?
Yes.
Anything else for today, gentlemen?
I would just mention that the proposed orders from the defense are still pending. I don't know that I've seen them, but I just wanted to mention that since we're already talking about the proposed orders.
Okay. Mr. Lamar, do you have anything pending?
I imagine. What number are we closed?
So the statement we filed the memorandum before the last hearing included a blank next to all of the motions that we don't have orders of the record for. And I think that each one of those were ones the defense was going to supply to the court. If the court would like the states to provide them, it wouldn't be for this week, but I can provide some work for those as well. But I've believe the state has turned in, other than the one that the court asked us to turn in today, all the proposed orders that we were responsible for.
That might be something that might be appropriate as well for us to kind of button down tomorrow. Maybe you can talk offline and tomorrow we can put on the record exactly which ones that, that need to be completed, and Mr. Moore, Ms. Bellinger can kind of let me know when you all think that would be able to be accomplished by, given also your circumstances of transition. Okay. All right. Anything else I need to take up for today?
No, Your Honor.
Okay, all right then. I will see you all tomorrow morning at 10 o'clock, and we'll continue with the other two matters that we have left. All right. Okay, we're in recess.
Thank you.
All right.
Thank you for noticing that. And this is yours. I have a conversation for the office. The document you show is 500
I will, I'm pretty sure. I'm going to sure I'll get back.
Can I give you Dwayne's number? Is that cool? Can you come down or I can...
You want to airdrop it?
Yeah. You-
Be DeMarcus.
'What's your number?
404
404.
295 7902. Yes.
Yeah, you'll be there. I'll be back. Did you guys have a recorder on this?
I don't know if we're putting anybody.
All right, y'all. He gave his number online, right? All right, y'all. See y'all later. Bye.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment